Hello and welcome to the SEC's Regulation Best Interest and its Impact on Structured Investments. Thank you for joining us for our webinar. Before we begin, we'd like to cover a few housekeeping items. To ask questions, please use the Q&A widget on your screen. We will try to address questions throughout the webinar, and otherwise we'll get back to you via email. For those of you seeking CLE credit, please download the affirmation form and the evaluation form found in your resources widget on the screen. We will announce the CLE code once during the middle of the presentation. Please return both forms for CLE credit. The presentation and supplemental materials are available for download from your resources. We will also distribute these via email after the seminar. So we are touching a very timely topic, and what we hope to do is not only provide a very short overview, which some of you have heard before, but this is an area of high priority for FINRA, so regulation best interest and the relevant Form CRS requirements. Our focus today will be on the anticipated effects for market participants in structured investment sector. So we'll introduce ourselves and then move to an agenda. Let me first turn it to my co-presenter, Tom. Would you please introduce yourself?
Thanks, Marlon. I'm Tom Greigel. I'm a principal consultant at ACA Compliance Group. I've been working with ACA for about the last 5 years, and prior to that I was a FINRA examiner, and even before that I was a registered rep, and I was such a good registered rep I went into compliance, so that tells you how good of a rep I was. But the point being is I do see things from both sides, and I generally work with broker-dealers on all their compliance measures, and I've been working on Reg BI ever since the failed DOL proposal. Thanks, Marlon.
Pleasure to be doing it for you, Tom. And this is Marlon Paz. I'm a partner at Mayer Brown. I head the broker-dealer practice. Reg BI has been of great interest to clients. My history in the broker-dealer side goes back to working on the floor of the New York Stock Exchange, late 80s, and kept my touch with that side of the world through law school and then in private practice for the last couple of decades. I also worked for a regulator. I worked at the SEC in the Division of Market Regulation, later Division of Trading and Markets, and have been very involved with IABD issues throughout, mostly from the perspective of the broker-dealer side, whether it be soft dollars or the hedge fund task force or anything like that. So this has been a topic in one way or another that's been a long-standing topic of interest. Turning to our agenda today, again, we'll cover an overview of the regulation, talk about some types of conflicts specific to the markets that should be discussed, and focus on and if you do not face retail investors, or retail customers rather. What changes are retail-facing distributors or intermediaries likely to require from product manufacturers? Any guidance from the SEC or FINRA to date? And the proposed changes to FINRA suitability rule to conform to Reg BI. We'll treat those at a high level as we move through the topics, and you'll see that there will be questions we interpose there, and any questions we receive from you will largely flow in this among these various topics. So without further ado, I'll turn it over to Tom to begin taking us through an overview of the regulation. Tom?
Thanks, Marlon. And as Marlon said, we're trying to focus on implementation, so we're not going to go too deep into the nuts and bolts of Reg BI. However, the background is always important, and there are parts of the nuts and bolts that I think will also work well into the discussion regarding implementation. So as everyone probably on this call knows, Reg BI was proposed by the SEC in June. It became on June 5th. The final proposal came out with an effective date of September 10th, and then the compliance date of June 30th. As we all know, we're counting down to June 30th. We are 4.5 months away at this point, so time's running out. Reg BI applies to retail customers, and it's a different definition of retail customer. As you can see, it's a natural person or legal representative of such natural person who receives a recommendation in a securities transaction or investment strategy involving securities from a broker-dealer, or a natural person who is an associated person of a broker-dealer and uses the recommendations primarily for personal, family, or household purposes. As we'll go into a little later, this poses something different as opposed to accepted practice regarding certain institutional customers. This retail investor definition kind of expands on what's been happening in the market for a number of years now. And then, again, the big thing is about a recommendation. What is a recommendation? Recommendations could be, generally it's accepted as recommendation as a call to action. All right, so if I'm recommending an account, whether it's a broker-dealer, a brokerage account, or an investment advisory account, that could be a call to action. If I'm recommending a certain product, for instance, a certain fund or alternative investment, those could be call to action. If I'm discussing a rollover, that you should roll over your 401k, and as we know, rollovers is a big concern in this regulation. So that would be a call to action. So it's really about a call to action, and there's a fine line between education and recommendation. And I know a lot of firms, especially in the alternative space, maybe in certain instances, may be relying more on education versus recommendation. Everything that you know is going to come down to how you present it and document it. But again, it's all based on recommendation to retail customers. That's Reg BI in a nutshell. Then you have the overview of some of the things that to consider regarding Reg BI. You have, the general obligation talks about, being able to apply to all the certain the obligations under Reg BI, and there, certain things you need to do. You have the disclosure obligation, where you're going to have to disclose your capacity, your fees and costs, time and scope of services, your limitations on your recommendations. For instance, if you have a limited menu of products, which a lot of alternative investors with an affiliated BD may have, that they're only offering products that are issued by an affiliate, so that would be a limited menu. Then you have the care obligation, which is, again, care obligation is based on actually FINRA suitability rules. Your customer rule, your suitability obligations, and the main premise of the care obligation is that you're acting in your client's best interest. Of course, the trick is how you're going to be able to demonstrate and document how you're acting in your client's best interest. One of the areas that is of particular concern, besides the disclosure obligation, is the conflict of interest obligation, because you have to be able to identify your conflicts of interest, and then you have a couple of options. Is it something that can be mitigated? And generally, if you can mitigate it, you probably have to disclose it. And if you can't mitigate and disclose it, then you're going to have to eliminate it. And they've already said that certain things, sales contests, non-cash compensation, and bonuses that are tied to the sale of a specific product are, need to be eliminated. And then you have the compliance obligation, which is pretty much a catch-all. In the original obligation, the original proposal, they didn't say anything about the compliance obligation. It was just the three obligations, which inherently they say you have to have policies and procedures for it. For some reason, the SEC felt that they should just throw in there a compliance obligation saying you have to have policies and procedures to be able to comply with the other three obligations. So, that's it in a nutshell regarding Reg BI. And now I'm just throw it over to Marlon about, how does Reg BI apply to me?
That's the big threshold question for us, right? we've already talked about the definition of retail customer as one of the initial gating issues here. But note that it encompasses a broad spectrum of accounts, not traditionally considered retail. So the first thing in this area that we counsel, particularly when dealing with structured investments, is rethink your conception of what is a retail customer and what is not a retail customer. Many have been wrestling with the definition of family offices and which bucket to put family offices in. And I hate to sound lawyerly, but it depends. And the guidance from the SEC, while somewhat there, I think more would be useful. And so many of us are pressing the staff to help us get additional insights as to what is a retail customer and what is not. A seemingly easy point, but one that can lead to a lot of confusion. And because it's a gating issue, it's one that we have to get right. FINRA institutional accounts, for example, may include some that are under Reg BI considered to be retail customers. So do not be guided by that definition. And I would tell you that there are lots of different iterations of the customer that one should keep in mind. For example, just because the customer comes to you as a corporation, an LLC, an Inc., or a partnership, that's not the end of the analysis. Maybe that's the beginning of the analysis. So, Tom went through the definition of retail customer. It's in your materials. I think that rethinking that and relearning whether your customers fit in that bucket or not will be a useful and advisable exercise, and one that you should take a look now as part of your implementation to ensure that, one, you demonstrate your willingness and attempts to comply, but two, more importantly, so that you are able to adequately assign whether someone is retail or institutional for your purposes. Another area, a gating issue between the definition of retail customer and not, is along the lines of direct contact versus indirect contact with retail customers. So let's assume you determine, as many of our clients in the institutional investment space do, that they don't really have no direct contact with retail customers. They might sell to distributors or others, and the question is, why should I worry about Reg BI? It doesn't apply to me. Well, consider that even if it does not apply directly to your firm, it does have the potential to change how your firm does business. For example, some retail-facing firms may require additional information from non-retail firms in order to comply with their obligations of Reg BI. So disclosure is at least one aspect, and there are many others that could be an issue, even if Reg BI is not directly applicable to you. Because of downstream relationships, it may become of greater relevance. I'm going to pause here and see if Tom has additional comments on does Reg BI apply to me, and then turn the next slide over to Tom.
Yeah, I think it's an important point that you're bringing up, especially with the retail customers, because pretty much it's been accepted in the institutional world that if you have, the institutional, it's been, again, accepted that usually an institutional investor could include individuals who have $50 million in assets, or $50 million or greater in assets. And under Reg BI, they specifically, actually even recently in their FAQs regarding Reg BI, they specifically restated that this is not the case. There is no dollar amount that an individual cannot be applicable to Reg BI. They stated that, what they said, because they feel that even sophisticated investors can benefit from the requirements of Reg BI. So that being said, that's where I know, and I'm sure you run into this all the time too, is, I talk to private placement shops or other, broker dealers who are, placement agents for private placements or actually distributing other affiliated products like structured products or such. They run into that normally they say we don't have retail customers, and this throws it off, because then the other thing that says is, as far as if you have representation, if you go further into the rule, representation really is if you have a representative on top of the account that's not affiliated with you, they still need to be a financial professional that's regulated by the financial industry. So in other words, and correct me if I'm wrong, Marlon, but if you're an attorney as the representative for a family office or as an individual, that doesn't count in leaving this person or family office from being a retail investor. I've read the rule several times, and that keeps coming back, that it has to be only if there's a financial professional who's the representation of that client. So that's the the really important thing is that all these firms that again and again say we don't have retail investors, and well, hey, wait a minute, guess what, you do, and that is a whole world that they're not used to.
Absolutely. So
again, Yep. So we go to the disclosure obligation. I think the disclosure obligation and the conflicts of interest obligation are two that are really causing a lot of firms headaches and a lot of time and energy to be able to comply with. Obviously, first of all, the disclosure is, what needs to be disclosed, and then when. So they talk about all material facts relating to the scope in terms of the relationship. Are you acting as a BD or, an IA? Materials, fees, and costs that apply to the transactions, and that's a whole, area ripe for interpretation. What are you considering material? And Marlon, I'm going to throw this to you as an attorney. I think one of the things is a firm is going to have to define what material is. Am I wrong in that?
Yeah, I think guided. There's some guidance in that, but very little. And I think what is material could include, for example, items around compensation and compensation for due diligence, which I think we'll talk about a little later.
Right. So again, it's all about materiality. And then, of course, when are you giving these disclosures to clients? I guess I go to Form CRS, even though it's a separate regulation that came out on June 5th. It's pretty much in lockstep with Reg BI. According to Form CRS, you would provide Form CS at the earlier, for a broker dealer anyway, at the earlier a recommendation. When you make any kind of recommendation regarding the type of account or a recommendation of a security or an actual opening of the account, the earlier of those. So I would think that the rest of these disclosures is the same thing. You have to kind of, they're going to go in lockstep with Form CRS, so you're probably putting out these disclosures, at the earlier of those times. And then again, we talked, and then, it brings up about oral disclosures. The problem with well, first of all, I've heard some firms say that they may try to rely solely on oral disclosures other than Form CRS, which I don't see how they can do that. I haven't seen anything with, my understanding of oral disclosures is usually if there's a material change and you haven't had time to update any of your other disclosure documents, that's how you could do an oral disclosure. And then, of course, the challenge is always, documenting it, and also when you document it, how you're ensuring that you're documenting when this was given to the client. So the disclosure obligation, obviously a big obligation. The broker-dealer world, I would say, is moving more into, which was kind of what the rule was trying to do anyway, into the IA space, because obviously the IA space has been putting out tons of disclosures in their IA, in their ADVs, Part 1s, 2, and now Form CRS will be Part 3 for them. So I think they're moving the brokerage, and the brokerage industry's always had a whole lot of disclosures anyways based on other rules. I think this is just a way of kind of putting it all together. And then the other thing is, conflict of interest. I think one of the big challenges firms are having is, first of all, defining conflict of interest. There are FINRA rules regarding conflicts of interest. The main conflict I always see initially is compensation is one big conflict. Especially when you talk about funds, is there 12B1 fees, revenue sharing, all kinds of fees that no one sees. So conflicts of interest, you have to define what your conflicts of interest are. Then you have, obviously, for a lot of issuers, it's proprietary. If you have an affiliated BD or a duly registered BD and they're offering affiliated products, you have that conflict. One of the conflicts you're always going to have to say to disclose is whether you have offering products from a limited menu. And I think probably a lot of people in the alternative investment space, that is what they're dealing with. They're dealing with broker-dealers who may be only offering affiliated products or products from maybe only one or two issuers. And then we go about the care obligation. I mean, the care obligation is pretty much saying, again, it's FINRA's suitability rule. You have reasonable basis suitability, where you have a reasonable basis to believe that a recommendation is good for a certain group of customers or investors. You have customer-specific suitability. Now you're taking the reasonable basis one step further, saying, okay, what I'm recommending is suitable specifically for this customer. And then you have the quantitative suitability, which is basically saying that I've got these series of recommendations, and then when you take them all together, that they are suitable for this investor. And that's really what the care obligation did. It took the three components of the suitability rule and applied them to the care obligation. What's interesting is there's a lot of talk. FINRA initially said they're going to have to change the suitability rule to comply with Reg BI. Then they said we may not have to, which I thought was kind of, I don't know how they're going to do that. They have to change it. They have to still keep it because you do have, the institutional suitability component of the suitability rule. But whether FINRA is going to change it or not, they've already said that they're going to, when they do examinations, they're looking at you complying with SEC regulations regarding Reg BI, which is similar to what they do with other areas.
And Tom,
so
we have a question on suitability, which I think it'd be good to cover right now, which is whether the concept of suitability prescribed by FINRA rules in their notices to structured products gets incorporated into Reg BI or the Reg BI concept from the perspective of firm policies, and does that need to be explicitly called out or defined or both? So I'm happy to take a run at that, or unless you want to cover it in this section.
No, please, you go right ahead, and then I'm sure I'll have something to say.
Good. Well, listen, the way I think this question, let me back up a little bit on it. From a broader perspective, think of regulation best interest as a set of rules that comes from the SEC, and then the FINRA notice to members and their guidance vis-a-vis structured products, in large measure, was seen as his jumping off point, Rule 2111. So it was looking at suitability obligations, which goes a little bit broader in the FINRA side on suitability and suitability concepts. Reg BI I would view as its own independent requirement, but because we don't have, at least at the moment, a full understanding of how the two mesh up together, we are being asked to interpret the two requirements, 2111 and then Reg BI, as being read as consistent as possible. And so if you're reading it as being consistent, or try to read those as to being consistent. What I would say is you should consider that the guidance provided vis-a-vis structured products as helping you or assisting you in compliance with your Reg BI, Reg BI obligations. So, what Tom just went through, the reasonable due diligence, care, and skill looks to reasonable basis suitability, looks to customer-specific suitability, and looks to quantitative suitability. Those three prongs come from 2111, and the guidance that has been offered in the structured products area in the notice to members uses that as its jumping off point. Tom, let me turn it to you to add.
Yeah, I come from. Unfortunately, sometimes I look at it from when I was at FINRA as an examiner, and as we know, FINRA has for a long time has scrutinized structured products. They scrutinize private placements. They scrutinize leveraged ETFs, any kind of structured notes. They feel that, and then REITs is another one. They've been scrutinizing them for a long time, and rightfully so, because in some instances you may have reps. For instance, in the low interest rate environment we've been in for years and years, they're friends with reps were always using certain REITs was a big thing that a lot of reps might have sold REITs to clients who were looking for a better return, based return on investments as opposed to a money market. And we know, as everyone on this call knows, REITs are much more risky than a money market would be. But that's why I think they've been long scrutinizing these types of products. And I go back, as I said, I initially got involved in the best interest space under the DOL fiduciary rule. And in that rule, they actually, put out in the initial proposal, not in the final, but they actually put out a list of products that they considered risky, complex, and or illiquid. And it was interesting in reading that because they talked about target date mutual funds, exchange-traded funds, especially leveraged ETFs, hedge funds, private equity funds, REITs, structured debt instruments, insurance products that offer a menu of market exposures, derivatives. So you kind of, I think one of the things you have to do with the structured products is kind of see, all right, when you're documenting what's in a client's best interest, I think you have to have a little bit more documentation in showing how a certain structured product is in a client's best interest. I really think that taking the and the other thing, and part of that probably is what percentage of this client's overall investment portfolio, whether with your firm or not, this product comprises of your, like I said, of your overall investments. Because what you might find is, though it's 100% of the investment with your firm, a certain structured product, when you look at their overall picture, it may only be about 5% of their overall investment portfolio, and I think that's an important aspect you want to put into that. So, Marlon, and I saw we had another question you might want to address.
Yeah, so this is some more details of the types of institutional clients that could be in the scope of Reg BI. So I would say, think of Reg BI as covering customers of the broker-dealer that are within the definition of retail. There's also let's see, it sounds like the audio may be out. Give us a moment here to make sure everybody can hear. Okay, assuming the audio is back on, the question is about the types of retail or institutional customers that could be in scope of Reg BI. And that dovetails with sort of the due diligence for structured investment slide that we're in right now. So think of certain limited partnerships or certain trusts that may not be fully formed as trusts that are advised by a trustee. for tax purposes and the like, but also private trading groups. We've dealt with quite a number of examples. So there are partnerships or other groupings that may be in an organization form, such as an LLC or a partnership, that are really highly sophisticated professionals or ultra high net worth individuals who are coming together under this umbrella, this entity that's a pass-through entity. And what you get in your KYC is the name of the entity, LLCX. But really, that's, one or two or three high net worth individuals who are using it, otherwise meet the definition of retail in the sense that they're using it for household purposes. So I would be very skeptical of the front end description. And while some of those may be institutional accounts, ultra high net worth individual with, $1 billion of assets are using this as an additional trading vehicle for their personal investments. I think that's the kind of thing that would be caught, and you will only see, ABC LLC or ABC Corp, when behind that is really just one ultra high net worth individual who is using this for their trading purposes. So the question then is, when this is the scenario, where this is the reality, will distributors be more or less reluctant to sell certain products to retail customers? That's complicated in the sense that I don't know that it changes the landscape of the analysis that they would have had to do vis-a-vis the suitability obligations we discussed in the prior slide. The guidance on that, I think, remains. The appetite for doing so, I think, is ultimately a business decision, and so there may be a bit more scrutiny in the front end right now as they are implementing their compliance mechanisms for Reg BI to come to the originators and others to who are putting together structured products, whether it be the issuer and so on, to assist with the kinds of disclosures, the kind of information that would make it easier for them to sell certain structured investments. But I don't know that I would classify that as a reluctance. I just think that folks will be trying to figure out how to comply. And so this is the background that we're working with many of our clients to get through, to position distributors to facilitate the distribution chain. Tom, please chime in on any of these, but wanted to make sure we address the due diligence for structured investments.
Well,
for example, go ahead.
Yeah, it's very important. Obviously, any new product you're offering, you have to, it's existing regulations that you have to conduct a due diligence. There's no doubt. Reg BI reaffirms that you're going to have to conduct due diligence on structured investments. I think for a lot of issuers, it may come down to, and for broker-dealers, you have a couple things to think about. Okay, so now, again, we know that certain structured products have been under scrutiny from FINRA for a long time. It's going to not go away. It probably may even increase under Reg BI. So I as a broker-dealer, might start thinking, okay, especially because I have to demonstrate how a product is in the client's best interest. One of the things broker-dealers are struggling with is maybe reducing their menu of products, which also could mean reducing their menu of structured products that they're offering. So, that would be in the non-affiliated scenario. Obviously, if they're affiliated, they're going to offer whatever suite of products their affiliated entity offers to distribute to them. With that being said, I think what you might find is it's going to be a little more competitive for getting shelf space with broker-dealers. So we talked about, obviously the requirement to due diligence and the things that have to be done. One of the things I'm looking at with my clients is, all right, well, because the other thing is you have to also demonstrate, do you have reasonable alternatives in your space? So if I'm offering, 5 different structured products that are virtually the same from different issuers, I'm going to have to now demonstrate how I made that recommendation based on all the other alternatives. So you might also be reducing your shelf space for, the different types of structured products. Now, instead of having maybe 3 structured products that do virtually the same thing, albeit there'll be a little differences, I may only knock it down to 1. So then how do I decide which one? And I think this is where I think broker-dealers might try to leverage more, information from the issuer, saying, hey, what can you help? How can you help me more? Whether it's with training my reps on your product or, due diligence. I know I always have to get the information from you to conduct my due diligence. Maybe you can put it together in a way on your end that it doesn't take me as long to look at. That's when I look at the practical view of due diligence for structured investments, I'm looking more from the broker-dealer end is, what can you do for me?
Absolutely. Thank you, Tom. So, look, I don't think that this, alters dramatically the landscape, but as the distributors are, looking to place with retail customers downstream these products, and as folks are evaluating their ability to comply with Reg BI, there's going to be some. I don't think reluctance would be the right way to couch it, but I think it will be some, process of learning, of figuring out what compliance means in this space. So, some patience along the line is probably warranted. And so, Tom, why don't we turn it to? I'll turn it back to you for the conflicts of interest obligations, and we can go through that, and then talk, and then we'll come back together and talk about some of the questions related there too. So let me turn it to you first.
Sure, and as I alluded to before, this is one of the areas that firms are really struggling with, because first they have to identify, and it says, this, you have the disclosure obligation, but you're also going to have Form CRS, which is also going to have to put some conflict of interest in there. So, as the regulation says, you're going to have to identify and minimum disclose, any kind of conflicts of interest with your recommendations. Then it talks about identify and mitigate any conflicts of interest. And I'm not an attorney, but my understanding is when you say mitigate, you pretty much have to reconcile that conflict, right, Marlon? I mean, I'm guessing that's what my understanding of mitigate means, to be able to assure that you kind of be able to manage that conflict of interest. And then, of course, they talk about, certain conflicts of interest that you're not going to be able to mitigate and disclose, that you're going to just have to eliminate. And they give the examples of, the usual, bonuses and contests and non-cash compensation related directly to the sale of a specific product. So you have to make sure that those have to be gone. It's interesting because I know there are still parts, I go back, I know the insurance world, contests are still a big thing. Now I know they've done a lot to make it not product specific, but it's a fine line that they're always walking with that. So conflicts of interest, all right? You got to identify, which is the big thing. If you haven't inventoried your conflicts of interest right now, you better start. And then the other thing is there's got to be some kind of mechanism going forward, because you're always going to have to be looking to see what new conflicts may pop up when you're. We talked about the due diligence that you're going to have to do when offering a new product. Part of that due diligence is, is there a new conflict that I have to maybe disclose and mitigate and disclose, or get rid of it. Compensation, as far as conflicts of interest, to me the first thing that always pops in is compensation. As I mentioned before, you have revenue sharing and 12B1s and things like that. How are you managing those among all your different products? And again, it's just a matter of, the biggest thing they say about conflicts is that, you have to eliminate is that you can't, you basically cannot make a recommendation that benefits you more than a recommendation of another product. I mean, and that's the biggest conflict we all have. And I go back to under DOL, what firms were going to have to do is, kind of, take all their product groups and levelize the compensation among them. So for all VAs, I'm not getting more, this is the amount we're getting from all our distributors. For private placements, this is what we're getting from all our distributors. And that's where I think, again, going back to the issuers, they're going to have to play a role in working with broker-dealers on the compensation conflicts. What would you think, Marlon, regarding other issues of conflict?
Yeah, absolutely. And in fact, let me turn to the slide on that, because I think there's a number of special topics here. When the issuer comes into focus here is important, and while regulation best interest does not apply to the issuer, where it does apply is very important to the issuer and to broker-dealers helping the issuer. So where you have an affiliated issuer versus a non-affiliated issuer, I think that there's a number of issues here. One that we've been discussing in the context of preparing is, what if you have an alternative investment for which there is a payment for due diligence? Is that a specific disclosure? Is that a conflict that needs to be disclosed? Again, we treat it and we mentioned it briefly on the due diligence side of the world, but under conflicts of interest, that's one issue that I think we need to think about, and you need to think about within your firms, as to whether that cash compensation creates a conflict of interest that then must be mitigated, and by mitigation, I think it's disclosure, really. So that's one issue. Tom, do you want to expand on that at all?
Well, again, especially with this, one of the conflicts and disclosure issues is especially with affiliated issuers, if you're a broker-dealer and all you're doing is offering products from the affiliated issuer. So, you, again, in Form CRS and other disclosures, you have to say you're offering from a limited menu. And then, of course, now, to me, a big challenge then is if you're offering products from affiliated issuers as well as non-affiliated issuers, how are you managing that conflict that, inherently the affiliate, selling products from the affiliated issuer would benefit you more than the non-affiliated issuer. So I think those are conflicts you're really going to have to, and I guess the best way to do it is to levelize the compensation. But that's something you're going to have to work at. And again, I go back to when you're documenting, when you're making that recommendation to a client, you're going to have to really document how you've made sure, because again, if you're offering affiliated and non-affiliated, you have that issue as far as, reasonable alternatives. And if you have them, now they're not saying you have to have reasonable alternatives if you're offering from a limited menu, but it's something that you may have to consider.
Yep. And look, and there's a host of issues we put on here, like, for example, not just the distributors and how they've revamped their compensation structures to facilitate the compliance, which may create fees akin to a 12b1 type fees, the likes of which we may not have seen in the structured investments world. But think about electronic structured products platforms and what issues that could present, and also just if a rep is moving firms and the new firm doesn't have the same product, which often happens in the structured investment space, but there is another product there that you might think is similar, pretty closely akin to, I think that creates some issues. And so none of this is a showstopper. All this is, think about these things a little more deliberately than you have, as with now Reg BI as an additional point in your conversation. In the interest of time, why don't we move on to some of the compliance obligations? Tom, I think you could probably walk us through this fairly quickly.
Yeah, I mean, the compliance obligation is pretty straightforward. It's just an obligation that they, like I said earlier, it was not in the original proposed Reg BI. They just added the compliance obligation to say that you have to have, policies and procedures to be able to comply with the other three obligations, the disclosure, care, and conflicts of interest obligations. I don't think there's really anything more to be said other than, FINRA has said when they're conducting exams, they are going to ask you to see how you are doing as far as developing your policies and procedures for compliance with Reg BI. So that's where, you want to be able to demonstrate that you're complying with the compliance obligation, for lack of a better way to say it.
Yep. So we will now read the CLE code, and that is 02MB18BI. Please include this code on your affirmation form. Both the affirmation form and the evaluation form are found in the resources widget on the screen. And again, to repeat, 02MB18BI. Continuing on here, Form CRS, look, that's part and parcel of all this. So you got to think of Reg BI and its disclosures as well as the Form CRS, which is required of both broker-dealers and registered investment advisors, and it must be provided to retail investors in order to provide them information intended to clarify that relationship, the relationship between the broker-dealer and the customer, or the registered investment advisor and its client. To note what some of you may have heard of before, Form CRS requires a Q&A format subject to certain page limits. It encourages the use of charts, graphs, tables, meant to be accessible by the investor. It should include a link to SEC information, so broker check for broker-dealers. It'll feature a combined section that discusses fees, costs, conflicts of interest, and standards of conduct. So the stuff we've been talking about with respect to Reg BI. And specific discussion of proprietary products, third-party payments, revenue sharing arrangements, and principal trading is required. We're mentioning and highlighting those because of the focus of this particular seminar. They must include a section on disciplinary proceedings, and it's a conversation starter. So look, it's supposed to be detailing some of the differences between brokers and advisors, and where those services have been eliminated. It's to be provided to investors and filed with the SEC and available online. So if you all can still hear me, I think we may be having some trouble with the audio, but hopefully it's back on now. Retail investor definition on Reg BI and the Form CRS rules have been harmonized. So firms may file their initial summaries beginning May 2020. So I know that date is coming up, and that's why many are preparing, and this is why the focus on investment, alternative investments, because folks are trying to understand who has to file this and who doesn't. Turning to some practical considerations, Tom, let me turn it to you on this, and we'll both chime in.
Sure. I just wanted to say a couple more things about CRS. As we discussed previously, the definition of institutional investor is changed for Reg BI. That we talked about possibly family offices, individuals who have $50 million in investable assets. That these are now trusts that don't have that you might have your Uncle Joe as the trustee, even though they have over $50 million in assets. These may all be considered individuals required for Reg BI, which also includes Form CRS. But there's a couple other things that I've noticed with issuers, with affiliated BDs especially. A lot of times they offer these products to their employee In most cases they do it only if they're accredited, but and the argument they're going to say is we're not making a recommendation. We are, we're giving them education. We're just offering it out to them. However, so yes, if you're not making a recommendation, you don't have a Reg BI obligation. However, you do have a CRS obligation because you're affecting a transaction for those clients. So they would get a Form CRS. So this is something new, especially for those types of clients that they haven't done. Then, as far as, one thing that has always happened in the mutual fund world, which I'm, and Marlon, if I'm off base, please tell me, but in the structured investment world, you talked about reps moving to another firm and they don't hold that structured product. Well, if they don't get rid of that structured product and if it doesn't stay, and maybe it doesn't stay at the BD, where does it go? Do these issuers have, orphan accounts the way a mutual fund does? Because if you do, then those customers would have to have a Form CRS obligation if they fit any of the three criteria for providing a Form CRS, whether it's opening an account, and I would say if it's an orphan account and comes back to you with a broker-dealer record and you haven't had the account before, that would be considered opening an account. You'd have to file a Form CRS. So I think CRS is another area that a lot of institutional shops aren't used to dealing with as far as certain customers are going to have to do certain things differently.
Fully agree. Yep. So that's actually the beginning of the practical considerations. Actually, that's one of the very practical considerations.
Yeah, that's why it kind of straddled both areas. So I wanted to just make sure I brought it up. Outline your program. There's a lot of things when you're outlining your program. You have to decide. Again, you're going to have to do a conflict of interest inventory. We talked about that. You're going to have to decide about your compensation methods. Right. Again, I talked about possibly leveling compensation among product groups. But also you're going to have to take a look at your compensation grid. They talk about, I know this is a big thing under DOL, is that you can't have these big jumps where all of a sudden you have someone could sell one product and jump to a higher grid. You have to be able to monitor your have your compensation grid set up so it's not incentivizing people to sell the higher ticket products. You see here, again, we talked about identifying conflicts of interest. I mean, a timeline. I've talked to so many firms. They put together a working group, and they're started. Well, they have to tell us, put together their timeline. We all know June 30th. June 30th is looming all in our minds right now. However, when we talked about Form CRS can start being filed with the SEC, either for broker-dealers through CRD or IA through IARD, starting May 1st. And then, so you have to start thinking about that. How, do you want to file it sooner than later? Because one of the obligations you're going to have to do is within 30 days, you're going to have to then provide your CRS to your existing clients. It's that one-time deal. So that's part of your timeline. Again, talking to issuers, you're going to have to talk to all your issuers regarding compensation, regarding due diligence, regarding anything else they're going to do for you. Consider a code of conduct. That's something new for BD. If you have an affiliated IA, that's something they've been doing for years, and most likely your BD people are subject to it. But if you don't have an affiliated IA, that's something you might want to think about. There's a lot of FINRA rules that govern code of conduct, but it's in WSPs, and maybe there's a more cohesive way to put it together in a code of conduct to provide to your employees. Obviously, revising your policies and procedures. That's one of the big things you have to do. You just have to, you're going to have to adopt policies and procedures for Reg BI. You may have to adjust certain policies and procedures you have in place for other things to be able to comply with Reg BI. And then, how to document best interest. What you have to decide, how are you going to document it and how is it going to be able to be reviewed? You hear a lot of firms talking about all these electronic products they're using, whether it's, certain, sales management tools or whatever to be able to document this information. But who has access to it? Is it just the reps? If the reps are putting in documentation, or do you then, can the supervisors review that documentation? And then compliance. Compliance has obviously their oversight responsibilities. Does compliance have access to these types of tools to be able to look at what's going on? And again, it talks about updates to 17A3 and A4. I'm sorry, real quick. This one cracked me up when I read the regulation because they talked about, and please, Marlon, I'd love to hear your point on this one. They say that that Reg BI, they don't think they're asking for you to have any more documentation or get any more information from clients than you're currently receiving. However, they do expect that you'd be able to demonstrate to examiners, it actually says in the regulation, to examiners, your compliance with Regulation BI.
Yeah.
So that was under 17A3 and A4, yeah.
Yeah, I want to stress that point because, see, this is a part where you might have concluded, and you may have rightly concluded, regulation best interest is of no concern to me because I don't deal with retail customers. What I would say, in my practical perspective here would be, particularly in light of the question of how to document best interest, is if you believe that it does not apply, create your analysis, your internal notes of the fact that you've considered it and you have concluded it doesn't apply. That's a record 17A3 you create, and you can create that, and you can show that you've given it some good thinking, some good thought, and then look, then it comes. But that's if you don't believe it applies, I don't think that's the end of the analysis and you leave no records. If you do believe it applies, then I think an outline of your program, preparing a timeline for compliance, having and identifying those conflicts, those are things that you ought to be documenting for your protection when the examination staff comes in and says, we're here to understand your compliance with Reg BI. I don't think it's enough to say doesn't apply. Tell us how it applies. I think it's up to you to say, yep, we've thought about it, and either it doesn't apply, and here's our memo to the file on that, or before June compliance date, or it does apply, and here are the steps we took to comply. And look, this is our earnest attempt to comply. I think both of those would put you in a best position, even if you haven't quite gotten as far as the examination staff thinks you should have gotten. That will put you in a better position. But those are some of the practical, sides. There's a number of them here. In the interest of time, as we're winding down here, let me turn to some of the recent developments. I just want to make sure you understand are out there. This is guidance. We expect more to come, but we've put in the slides 4 sources of guidance that ought to be things you take a look at. Because they do provide. The FAQs ought to be updated periodically, so take a look at those. But note that it is a priority. It's part of the priority letter. I don't expect that to go away, but stay tuned for the next priorities letter, early next year, and I think you likely see it there again. There is still some concerns about the Reg BI, but note that the sales practice rules proposal by the SEC does have does touch on Reg BI, and I would dare say goes far beyond Reg BI in that in some instances it does not require a recommendation. So when it comes to sales practice rules proposed by the SEC regarding leveraged or inverse investment vehicles, that is an area that you really ought to pay some attention to. I think we'll do a webinar on that one as well, but I'm working with SIFMA on some comments to that. But stay tuned because I think that is of great concern. Tom, let me turn slide 23 back to you.
Okay, this was in the FINRA priorities letter, so I just want to touch on it quick. They gave this list of questions that they said when they're going into firms, these are the things they're going to ask. So again, it's just an additional resource, but this is a great start. If you want to have an idea of where you stand in your process, you might want to just look at these basic questions and ask yourselves, how do we, where do we stand with this as far as our compliance and being able to be ready for June 30th. So again, Lots of resources out there. This is a good one just to give you some basic way to look at where you stand right now. And I turn it over to you guys to close up, Marlon.
Thank you, and that takes us exactly to 1 hour, and don't want to abuse of everybody's time here. We are very thankful for your joining us for this webinar. Hopefully it's provided you a roadmap of some things to consider in this space. We believe this is a very important area and one that we hope will have more guidance, but we've tried to glean for you the best available information as Reg BI's impact on structured investments. Thank you for your participation, and with that, we will close out the live portion of this.
Thanks, everyone.
Thank you.